Well, we're into week 2, and this module probably should be called documents because that's what it really covers. And uh, we're going to start out with probate and then get into some of the other documents such as power of appointment. However, I'd like to note just at the beginning, before we get too far into this week, that these documents should be prepared by a lawyer, and it should be not a boilerplate forms that you buy from a lawyer, but actually have the lawyer prepare the documents specifically for the needs of this particular client. I've seen too many times where financial planners and CPAs have a lawyer prepare a boilerplate document, use it for the client, and it being inappropriate for the client. I especially see this true when I'm doing an estate tax form, a lot of money involved, and the document doesn't really reflect what the client was after. And that just happens too often. So again, don't do it on your own. Use the experts, the lawyers, to do the documents. You're not doing your client a favor by trying to help them away. First of all, what is probate? Now, we're going to start off with probate because that is where wills and intestacy both are happening. I would say in today's society, we're so much into will substitutes that so many people are forgetting the real value of probate and the real value of the court system. It's going to have a lot of deficiencies. However, for most people, it's the appropriate way for them to take care of their assets when they die. Purposes of probate are really to identify the persons who will receive the decedent's assets. I might note that when I say persons here, I also mean institutions such as charities, because many times charities are a major factor in the assets being distributed at death. And I think the other major thing we should go right up front is probate requires proof that it was the last will and testament of the decedent. And might note that before you die, you're called a testator. That's the person who writes the will, and when you die, you become the decedent. And the question many times is, the client has written 5 or 6 different wills while he was a testator, which is the last one? And that is very difficult to prove which is the last one when there are so many out there. Intestacy is very common. First of all, it's used when there is no will and there's no will substitutes being used, and that does happen quite often. People delay it. I have seen a lot of people in their 50s, 60s, even attorneys who do not have wills, because people don't want to face death and the consequences of thinking about death. So do not be surprised if your clients are reluctant to have a will. Unfortunately, they probably don't have will substitutes either. I think it's a lot easier to have a will substitute, but probably isn't appropriate for most of your clients. A will may not cover all the assets, and they are assets that are not also under will substitutes. For example, you may have covered your assets listed specifically in your will, and you left off your automobile. And it's not on a will substitute because it's registered to you. That would be an example of intestacy. And the will is found to be partially or completely invalid. This could be caused by the fact that it was a form will bought at a stationery shop that was incomplete or wasn't appropriate for the state, that the will was written in another state, or that things have changed, conditions have changed in the state they're located in. Be aware that the probate judges try to save as much of the will as possible. They're not in there to destroy the will. They're in there to save as much as possible, but at the same time, they have to obey state law. So I would say that if you have a will and there's minor issues involved, quite honestly, it probably won't be a problem. It's when it's significant, such as it's inconsistent with the state law. Okay, responsible party who's going to carry out your wishes of the decedent. And that's probably another thing that's very hard for people to decide on. Who should be the responsible party to carry out their wishes? If you don't see a lawyer, you're probably going to pick a loved one a spouse or children. Unfortunately, they may not be technically qualified to be able to do the job. They may have the enthusiasm, they may have the desire, but do they know how to do it and do it correctly? So I suggest that again, that when you have your will filled out or your trust or other will substitutes, that you talk to the lawyer about who is best to do it. I think most of them will recommend that you have a trust company or a bank, professional executor or professional administrator, plus maybe a family member. The advantage is here is the family member knows the problems of the family, knows the importance of getting things done in a reasonable time, where the professional is an expert on doing the process and also protecting the parties, such as not releasing the assets until we know what the debts are, until we know what the taxes are. This individual, be they a family member or an institution, is called a personal representative, and it's responsible to the probate court for keeping the proceedings in motion. In other words, that it doesn't get bogged down, ensuring completion of the entire process in a timely manner, which again may be 3-4 years or even longer depending on the situation. For example, let's say there was a major car accident, or there was a person died in a hospital during surgery. You may have lawsuits that'll take several years or more to get resolved. I think what the personal representative has to remember is there's two purposes of probate besides what we've talked about on the previous chart. One is paying off the debts and taxes so that there's not a lien against the beneficiaries. And second, we distribute the proceedings assets in a responsible manner. That doesn't always happen with will substitutes, and certainly will substitutes seem to ignore the debts and taxes. A specific bequest is the real or personal property set forth in will that goes to specific beneficiaries. That could be a car, it could be a vacation home, it could be the residence, it could be jewelry, whatever. A general bequest is a portion of the share of the assets usually paid out in money, which is pecuniary. And I would say that the average will has both. I think there's some big advantages of the general bequest because of the fact that it's easier to give money than to try and find out which jewelry was applicable, or if it's the same jewelry, or if it's the same automobile. So general is better there. The unfortunate thing is what happens is we pick out the specific bequest, and then everything else is put in an estate sale, and you get a big discount in the value of it. I think any of you have gone to an estate sale, you know you get some pretty good bargains, because the goal of the estate sale is to get cash fast, not to get the best price for it.